New Always Talking Shit Show.
Yo.
What's happening?
What's
It's your
good,
boy
man?
Doggone.
It's your boy King Magic.
You're in tune with another episode of the Always Talking Shit Show.
I was doing some shit over here.
This nigga almost went back to the old name.
Hey, what's popping though, man? What's good with you? How was your weekend? How was your week?
I mean, how was my week? You ain't,
All that
you
other
don't
good
even see
shit.
me since Monday.
Oh, nigga, last time I was supposed to see you, you stood me up again. But we don't gotta talk about it, man. Which is when you come on here, popping your own nigga. You don't ever, yeah, man. Same
You
line.
realize I haven't said that shit in in a good little minute,
I'm just
right?
saying. But you had said it before several times.
Stop though, right?
All right, well, I gotta get my shit off. I gotta get my shit off too. You know what I'm saying?
I haven't said that shit in a good old little minute.
I'm like,
right?
damn.
Like, nigga.
I ain't gonna lie. I pulled up. It was kind of cracking. I didn't even get out the car.
Oh shit.
Real shit. Once I realized I had listened to like 3 songs, nigga, and didn't find no park, and I was dolo.
You know, shit was lit.
It's like, that's another cool thing about going to places dolo sometimes. I told D that once. He ain't believe me. So that nigga went out a couple times dolo. Had the time of his life.
I can't bring myself to do it.
You got to try it at least once, my guy. But yeah. So I ended up coming right back to the crib. But that shit was funny. It's like, man, I really don't even want to come down here. Like I was just, you know what I
I
mean?
ain't made, like I said,
It was just one of them things where we were just gonna go, just be on the scene. But like, to be real, until we get another promotional pack, just grab another one. It don't really, unless we just want to go.
Right.
It don't make no sense to really try to make it an issue. I've been fumbling with First Fridays since I moved back down here, bro. I've probably been to 2, and that's since you've been here.
Mm-hmm.
And I'm counting this Friday.
The one that you and your sister.
Yeah, that count.
bopped
But this
out
one
on,
count
and
too,
then
nigga. I
this
went
one
down there.
bopped
You
out
feel
on,
me?
Right.
But other than that, fam,
Same shit.
my nigga. And if it wasn't Latrice, like I probably wouldn't have went. To be 100.
I gotta we're gonna start this a different way. Somebody asked us a question.
It's all good. Shoot.
You asked on did you meant to say Black Monday?
What are you talking about?
This is your post. This isn't mine.
Oh shit.
Did you mean to say Black Monday?
No, back Monday.
All right, so what's the number one subject
What did I say,
you want
black?
to talk shit about? No, it says back, but it just didn't make sense to me. Back Monday, or
That was for Monday though.
I know, but somebody asked us.
Somebody
question.
responded. Oh, okay.
Yeah,
All right,
yeah.
for sure. Who was it, man?
Somebody named Tobias Stewart.
Oh, okay.
I feel like we know
I fuck
him.
with. Yeah, we do.
We do know him. Okay,
My
I was
guy.
like,
Go
I
ahead.
know
Go
him.
ahead. Shoot.
He said,
What'd he say?
I'd like to hear your opinion on Michael Wadsworth sentenced to 55 to 100 years for shooting in self-defense in Washoe County by all-white jury and was represented by a then practicing marriage attorney who had no experience in murder litigation.
Damn.
He is a friend of mine, and we are trying to get him pardoned. So if you look into that just a little bit, it would be really cool, just my opinion. So, for you, Tobias, we will look into this right now for you. We're gonna...
No, I'm somewhat familiar with the case. You know who that is? Nigga, that's Job.
Oh, Mike.
Yeah, bro. Like, so
Is he really? He's talking our nigga Mike?
Yeah, so
55 to... Oh,
so
no.
if I'm saying that this is like,
I was wondering what happened to
this is
Job.
what I heard. I don't know the story, because it happened shortly after me and Ja had issues. You know what I'm saying? Me and him got into 2 fights. We don't really fuck with each other. But
hey, Tobias, if you watch...
hold on. But at the same time,
I know that boy.
I'm not with nobody spending 55 years in jail. Really, I don't think nobody should go to jail personally. But yeah, I don't know. I didn't know that. I didn't know the details of his of who his attorney was. You know what I mean? I didn't know. I kind of don't want to. I'm skeptical about speaking on the story because all I know is like what the street said. You know what I'm saying? But I'll give y'all the street rundown of what I know. You looking it up right now? Mm-hmm. All right, you tell me because you gonna clean it up with what the people say. I'm gonna tell you what I heard in the streets. Well, shit. Nah, I'm not gonna tell you what I heard in the streets. If he fighting for his release, nigga, I don't know if what I say might incriminate dude. Like, so yeah,
Tobias,
scratch that.
when you do watch this back, because you seem to be paying attention to the show, and we appreciate that.
No, that's my guy.
Michael Wadsworth. I grew up with this nigga. Like,
Yeah, he knows that probably, dog.
like Ja was the fucking now he's
So
telling
what
me,
he's saying is that
when he said you know him and he's like Michael Wad, I'm like Mike, like what the fuck?
Yeah,
it's
so
been so long since I heard
read
that
what
name.
they said, because I want to hear if it's lined up with what I heard.
This is from
so that way I know what I can say or not, nigga.
Legal.com or whatever.
Well, what is it?
Legal.com.
Oh, okay, my bad.
Says Wadsworth was convicted of murdering Jose Esperanza by shooting him, causing the ruptures from femoral artery. The state presented evidence placing Wadsworth at the crime scene and shooting a revolver. Wadsworth's theory of self-defense was that the second gunman was present at the scene and fired the fatal shot. Wadsworth next argues. Go ahead. No, go ahead.
Because I don't want to get lost in it. So what Josh saying is that he shot the dude in self-defense because another dude had a gun and the other dude shot first? Okay, because I think they worded that wrong. Go ahead.
No, I think, Wadsworth saying somebody else was shooting as well.
That's what I said.
But wasn't shooting at Wadsworth, was shooting at Jose as well with Wadsworth. Wadsworth is saying he was not the one who fired the fatal shot to kill Jose.
So what he's saying...
He snitched without snitching. Wadsworth next argues that there was insufficient evidence to convict him because a firearms expert could not affirmatively state that the shots fired came from Wadsworth's revolver. The firearms expert testified that the bullets recovered from the crime scene came from a .38 Colt caliber revolver. He compared the recovered bullets to a .38 revolver found at the crime scene. The firearms expert testified that he could not conclusively determine that the Colt .38 recovered from the crime scene was the murder weapon, but he could also not exclude it. Wadsworth later testified that the .38 revolver was his and that he had fired the gun in the victim's direction, but that he had fired into the ground. No other weapon was recovered from the crime scene. It is for the jury to okay, hold on. So that's what his what he was saying. It says,
damn, bro. So all right, well, so we're gonna play devil's advocate on this one. I'm gonna play devil's advocate.
There's still, because we're going.
Okay, go ahead. No,
we're about to read this whole shit.
Do your thing. Do your thing.
So it says after that. So the court addresses the first petitioner's argument that the evidence was insufficient to support the verdict that the petitioner was guilty of first-degree murder. Petitioner cites that conflicting eyewitness testimony biased testimony of persons who were present with Esperanza, dubious testimony of the jailhouse informant. Ooh.
So hold on, stop right there.
There's a jailhouse informant.
Stop right there.
Told on this nigga Mike.
Stop right there. So, and there's also eyewitnesses.
Yeah.
That's like, they're saying, you shot him. Or they're saying you were shooting in his direction.
We're not saying that you shot.
And this is the part that I fear for him. First off, rest in peace to the victim. But this is the part that I fear for him is when you do shootings, like take it off him for a second. Me and you get in the car, and we pull up somewhere. I see somebody on. We get into it, and I start shooting. A lot of times cats go down for the same homicide because you was with me. You know what I'm saying? And so I think sometimes I fear that like those appealing to courts, they look at it like it don't really matter if you didn't shoot them. They won't come out and say it, but they're like holding that against them. But go ahead.
Petitioner cites testimony. The petitioner cites the conflicting eyewitness testimony, biased testimony of persons who were present with Esperanza, dubious testimony of jailhouse informant, evidence of another man with a gun being present, evidence of more shots fired than bullets recovered, and evidence shots being fired into the ground. Petitioner is presenting an argument why the jury should not believe this evidence. However, the Nevada Supreme Court noted correctly whom and what it believes is reserved to the jury, not to reviewing the court. Petitioner has not demonstrated how the Nevada Supreme Court decision was unreasonable application of Jackson versus Virginia. Regarding the weapon, people saw the petitioner firing a gun, running away, and dropping the gun into a trash can. Petitioner admitted the testimony he handled handled and fired the gun. The police recovered the gun. It was a Colt 38 special revolver. The police also recovered 3 bullets, 1 for Esperanza and 2 from the walls. The prosecution firearms expert fired the gun. He found that the bullets were a 38 special and that they were fired from the particular class of weapon based upon the number and twist of the marks of the rifle of the number and twist of the marks that rifling of the gun's barrel left upon the bullets. Good Lord. The class included the Colt recovered from the location of the shooting, but it also included any other Colt special revolver and any other gun chambered for a 38 special with the same number of twist rifling grooves. The recovered Colt did not mark well the bullets fired from it. Firearm inspector could not match some of the bullets, but knew he had bullets that he knew he test shot from it. In short, the firearms expert could not rule that the recovered Colt fired the recovered bullets, and he could not rule out that the recovered Colt fired that it didn't fire the bullets. Petitioner is not.
Well, stop right there. I'm sorry. So he's saying that he can't rule out if these bullets came from Josh's gun or if they didn't come from Josh's gun.
Yeah, he's saying there's no conclusive evidence to either way.
What the fuck? All right.
Petitioner has not shown how the Nevada Supreme Court decision was a reasonable application of Jackson versus Virginia. The court has already determined that the ground 1B is procedurally defaulted regardless of any alternative holding on the merits, and that the petitioner could not show cause to excuse the procedural default because the purported cause of itself was an exhausted ground which the petitioner demised. Reasonable jurists would not find the court's conclusion to be debatable or wrong, and the court will not issue a certificate of appealability for ground 1.
Wait, so they're not issuing him an appeal? Damn.
The court found the parts of ground 2 were not exhausted and they were dismissed. The remaining parts of ground 2 claims that the trial court erred when it denied admission of both petitioners and prior statements of the police and a videotape of the petitioner speaking to his grandmother after being interviewed by police. Regarding the videotape, Nevada's trial held. Following his arrest, Wadsworth was allowed to talk with his grandmother and aunt in police interrogation room, which had a camera and recorded the conversation. During the conversation, Wadsworth stated that there was another shooter at the crime scene. Wadsworth argues that the district court erred by not admitting the videotape of Wadsworth telling his relatives that there was a second shooter present when Esperanza was shot. However, a review of the court reveals...
Wait. Who didn't tell the relatives that there was a second shooter? Is that the authorities?
No, you're hearing me wrong. Wadsworth argues that the district court erred by not admitting that videotape of him telling his family that there was another shooter, of Mike telling them that.
So that's what I'm confused about. So wait, Josh seen, how did he see the family?
He's not talking to the family. Josh's talking to his aunt and his grandma. He's talking to his family.
On tape?
Yes, in the interrogation room.
Oh, okay. I see what you're saying. Well, they don't have to. Do you think they don't really have to show the tape? Do they? If they just let that be known. Well, I don't know, man. Damn.
It's one of them things that's not gonna help or.
Are you still
help or
still
his?
got more?
Got a lot.
All right, go ahead.
The part of ground 2 regarding the admission of petitioner's prior statements to the police is related to ground 4, in which the petitioner claims that he was forced to testify because of the trial court rejected his attempt to impeach the detective with his own statements to the detective. The court considers the two claims together. The Nevada Supreme Court held Wadsworth further argues that he should have been allowed to question the detective, David Fogarty. Why have I heard about that motherfucker before? About his statements to his grandmother and aunt concerning a second shooter at the crime scene. So they're basically saying that you never even investigated me saying that there was another shooter. You just, now you're saying
Did the
it's
witnesses say that it was a second shooter?
No.
The witnesses are saying there was no second shooter. It was just him.
The witnesses are saying that, yeah, they saw him shooting and run away from the scene.
Oh, well, shit. Damn.
A review of the record reveals that Wadsworth testified he told his grandmother and aunt that the second shooter was present when Esperanza was killed. Wadsworth failed to identify what additional helpful information would have been elicited had he had been able to question Detective Fogarty on this matter. Therefore, even assuming error, we conclude that Wadsworth was not prejudiced by any limitation on the questioning of the detective. Additionally, Wadsworth argues that but for the district court error in limiting the detective's questioning, he would not have had to testify because the second gunman theory would have been presented through the detective. However, the decision to testify is a strategic decision. As such, it was Wadsworth's prerogative to testify knowing the strength of the state's case. By choosing to testify, Wadsworth accepted both risks and the rewards that accompanied his testimony.
Wait, he took the stand?
Mm-hmm.
Oh, shit. Yeah, his attorney was ass. Why would she let him take the stand?
They said Detective Duncan interviewed the petitioner. So it says Detective Fogarty testified that nobody told him about the possibility of a second shooter. 2. Detective Fogarty is confronted with a transcript of a police interview of Cisco Neal, who said that there was a second shooter. So now there is an eyewitness.
On Josh's part, saying it was a second shooter. Shout out to Cisco.
The detective is asked on redirect examination whether there was any corroboration of a chubby dude with the gun. He says no. He says that Detective Duncan interviewed the petitioner and that he was present. He said he still had no information about the chubby dude with the gun other than Cisco Neal's statement. Petitioner argues that ground 4 is untrue because the petitioner himself gave a statement, or that part 4 of that is untrue because the petitioner gave a statement himself that another person was shooting and that he was not allowed to re-cross-examination to confront the detective with that statement. Although the prosecution could offer the petitioner's statement into evidence, it was in admission by a party opponent. Petitioner himself could not do that because then his statement is inadmissible as hearsay. Petitioner was trying to get his denial of shooting Esperanza to the jury without having to testify and be subject to cross-examination. Petitioner also argues that the trial court did not let him inquire about his own statement because the prosecutor asked questions on redirect examination. It was more complicated than that. Jesus Christ, this is ugly.
Yeah, it's not looking good for him.
He said the court's motion to bring in Mr. Wadsworth's testimony through the detective through his interview was denied. So I'm very concerned about what's in Mr. Wadsworth's statement. I do not have it. The questions deal with Mr. Hahn, the prosecutor, addressing the detective about Mr. Wadsworth's interview. If there is anything in Mr. Wadsworth's interview about a chubby dude with a gun, if he describes any people as a chubby dude, if he talks about a chubby dude being there, anything, I will let you get in. I will let you go into it. But if he doesn't, the door wasn't opened. And the reason the door wasn't open is that it was on redirect. After you have violated material orders, you have violated the court's decision numerous times. You continue to ignore the court's sustaining of objections and went into areas that you were not supposed to go into. Your defense counsel knew what you were doing. You made a tactical decision to do it. I'm very concerned that Mr. Hahn asked anything about Mr. Wadsworth's interview. I think that was unnecessary and that it's going to create a problem in the appellate court. But I'm here now. The question's clearly on my mind, both when read back to me as they happened, related to the chubby dude, and the fact that whether or not existed, or whether that he existed or not, and that whether or not it was police misconduct to not somehow find the chubby dude. And I'm asking that, taking into perspective, as Mr. Wadsworth asked, as I've asked 2 times now, said in his interview there was somebody described as a chubby dude with a gun who was either with a gun or shooting a gun. I'll let you go into it. Otherwise, it's improper and I'm not going to allow it. And I'm concerned with this whole process because it's certainly creating enough muddy of the water, the appellate court, to have lots of fun with the transcript. And I'm not particularly pleased with the way it's going. Holy shit.
So,
Judge talking.
is that so? He has the same attorney, right? Is the same attorney he's trying to go for his appeal? So when he got, this is my thing.
But do you?
I thought when you were convicted, you automatically got an appeal.
Not all the time.
For real?
I don't think.
See, I've heard of cats exhausting their
I don't know.
appeals, but he's had to have had an appeal already. And then maybe this is like
this has been going on from like 2017. Usually,
hell no. This is way longer than that.
You get hella appeals, so they tell you.
Way longer than that, because that happened to him short. Dog, matter of fact, bro, I'm gonna be 100.
Wasn't that shortly after high school?
I don't probably for y'all, but I'm gonna be 100. Me and him got into it the second time, and that's crazy, bro. That's crazy.
It's just deep.
It's a deep situation. That shit sucks. So look, this from what I'm hearing so far with his situation, where I feel like there is some, like, in a fair world, there's light at the end of the tunnel. But from the way that judge is talking like, you're gonna eat this time, and I don't want to hear nothing else. And that's scary. I don't know if that's ethical or unethical. It sounds like the judge is accusing them of trying to muddy the waters a little bit. But as far as Skull speaking out on his behalf and saying, like, no, there definitely was a second shooter. One of the things I'm thinking is that, like, okay, I'm guessing the second shooter allegedly is the chubby guy with the gun. They don't specify his race or anything like that, right? Just a chubby guy with a gun. Now the alleged eyewitnesses to this, who they keep nameless, right? Of course, they seen their witness statement is, where'd this happen at?
Doesn't say. Or this doesn't say.
Their witness statement is they seen Ja shoot the dude.
All right, hold on though.
Take off running.
They're
throw
gonna
his
talk
gun
more
in the trash.
about the chubby dude. We gotta keep going. It's just long as fuck.
I didn't even want to do all this. All right, go ahead.
The trial court did not bar completely petitioner from using his interview. Well, after that, we can talk about this last little part in the weekend, because it's basically, it's going in circles.
Right.
And we're at the chubby dude. Well, they're about to talk about the chubby dude again. There's some more.
Well, give it to me. No, give it to me. Give it to me.
Every little bit more. Said the trial court did not bar completely petitioner from using his interview with the police. The trial court did allow petitioner to impeach the detective with any statements by the petitioner in the interview about the chubby dude being present with or without a gun. The petitioner did not impeach the detective with those statements because those statements do not exist. The petitioner only said that he heard shots and that he never gave his own description of the shooter. The petitioner's only description of the shooter was a second hand by other people. Even then, that description did not mention any chubbiness, only that the shooter was from California. So now we're like, okay, there's not a chubby dude, but it's a dude from California who was over there shooting too. So is there another dude? Motherfuckers just make this nigga up? Like,
So I'm
'Cause now
sorry,
we're
bro.
like, all right,
I
now-
got to text.
Now we're
Who
saying
is?
there's a nigga from Cal. Now it's like
So who's saying that there's a chubby dude?
It's all third. It's all secondhand.
So now there's
basically-
another witness.
So basically, somebody came. It's probably Skull came back to Mike like, "Hey, there was somebody, some chubby nigga too, shooting while he was over there." Because they're saying he's everything he knows of the chubby dude is off hearsay. He said he only heard the other shots while he was shooting. Everyone else, the other witnesses.
But does it
were
ever say?
ones-
Does it say his story of why he was shooting in the first place?
No, they don't say why this whole.
And there's only one round being found.
No, there was
2 different rounds.
3 rounds from a 38, but it's not conclusive to say that it is his gun. The other nigga
So
could
he
have
had
the same 38 revolver.
So, but he did have a 38.
But they
Okay.
both could have had a 38. If there's really,
I'm gonna be
another
honest with you,
shooter,
dog. There's light at the end of this tunnel
nigga.
if you have the proper legal protection. I fear for him is that, you know, they even stated that he doesn't have the greatest attorney or the most, you know, skilled attorney. And these kind of case, a murder, a body, it costs money. Because now you got to go get a private eye. You got to go get your own independent forensics team to create a reasonable doubt. Right now, what those people say is going to be law because they're the only experts in there. There's no expert to challenge it. If you get another expert on there that says, hey, I, in 30 years, will never conclude that this shell came from this gun because it's just not enough to conclude that. Now they got something in. Now they looking. Was it a jury trial? What's
We're
the
not to the end. Like this is the whole, because they're giving you like shit's being said on the stand and shit. I'm trying to get to like, because this whole ground 3 part, we don't even need to read that part. So it says Wadsworth next argued the district court erred in declining to give the proposed jury instruction. If the evidence in this case is susceptible of 2 constructions of interpretation, each of which to you to be responsible, and one of which points to the guilt of the defendant and the other is his innocence. It is your duty under the law to adopt the interpretation which points to the defendant's innocence and reject which points of his guilt. The district court declined to give his instructions, stating that it could be interpreted to change the burden of proof instruction, which could be improper. Court has ruled that so long as the jury is properly instructed on the reasonable doubt standard, it is not error to refuse to give instructions similar one that Wadsworth proposed. As the district court properly instructed the jury on reasonable doubt standard, we can conclude that it did not err in declining to give the requested instruction. So the boy tried to say, you gotta listen. It's basically say, listen to me, don't listen to them.
Who said that?
Mike was his plea to the jury. That's basically what they were saying in that statement.
Damn. What a sad thing, man. That shit sucks. I feel bad for him, man. You know, rest in peace to the victim as well. But if the person that isn't, you know, I'm for justice. But if the person that did it, you know, that's convicted of doing it, if there's reasonable doubt that he didn't do it, according to the law in our Constitution, right?
Okay,
That's supposed to be grounds for, like, you know,
so
I don't know
now
if it's
we're gonna
acquittal
get
or.
into, remember, he said, Tobias said Mike's attorney was an old like family divorce attorney. They're about to he's about to bring that into play now too. So let's read it again. Let's keep reading this shit. This shit is deep.
Now, before you start, did he pay the attorney?
I don't.
Or was this an attorney that was contracted through like public defender?
I think it was contracted through public defender.
Oh, see, now he might have a little more light, my nigga. Go ahead and read. Let me know. Now it sounds like he might have a little more light because.
So it says that
If they got him an incompetent attorney, that ain't his fault.
It said ground 6 contains claims of ineffective assistance of counsel. A petitioner claiming ineffective assistance of counsel must demonstrate, 1, that the defense attorney's representation fell below an objective standard, and reasonable Strickland versus Washington, that the attorney's deficient performance prejudiced the defendant such that there is a reasonable probability that, but for counsel's unprofessional errors, the result of proceeding would have been different. So it says, review of an attorney's performance must be highly differential and must adopt the counsel's perspective at the time of the challenged conduct to avoid distorting effects of hindsight. So he said, where is it at? Okay, in ground 6, petitioner claims that the counsel failed to investigate the case and it failed to understand the evidence. Specifically, the petitioner claims that the counsel thought that the prosecution's firearms expert had eliminated the Colt 38 special revolver recovered from the trash can as a source of the bullets recovered from the Esperanza and the walls. Petitioner based this upon counsel's cross-examination testimony of the evidentiary hearing in the state post-conviction proceedings. So here's questions and answers. It says question. So at trial, then his testimony was he did not fire the fatal shot. He fired into the ground. What I'm asking you is, did he tell you that? He authorized you to admit that to the jury. In fact, he had killed that man. Said answer. This is by a trial counsel. Again, I do not know that Michael ever knew whether, as I remember it, he fired blindly toward the ground. Questioner, okay. So I don't know that Michael, to this day, knows specifically whether his bullet hit the victim or Ace's.
Now he has a name.
The second gunman's bullet hit the victim.
Hey, this shit is crazy, bro.
Who the fuck is Ace?
That sound like the chubby dude with the gun, the second shooter from Cali. That's what that sound like. So either they know his name,
or are they just calling him Ace because they don't know they were calling him John Doe.
That's what I'm saying. We know we got a name for a non-name nigga.
And since we never got Ace's gun, the forensics never ruled out Ace. And and here's Michael, his gun, the one that fired the bullet, forensically can't be proven. So here we are. I mean, it was an unknown to the end of the trial. Okay. Petitioner argues that the emphasized portion of the counsel's testimony shows that the counsel incorrectly thought that the firearms expert eliminated the Colt 38 special revolver which the petitioner had possessed and discarded at the place of the shooting. However, in the very next sentences of counsel noted it was unknown whether the petitioner's gun had fired the bullet that hit Esperanza. In context, counsel likely was repeating the petitioner's argument that the petitioner did not fire the bullet that hit Esperanza and was not stating his own belief about the firearms expert's conclusion. In any event, the counsel's testimony at the evidentiary hearing is not what the jury heard. When the counsel cross-examined the Latiak, I don't even know how to pronounce that name. The firearms expert is what the jury heard. Question, Mr. L., you indicated that you could not eliminate this particular gun. Is that right? He said that is correct. It said you couldn't eliminate any Colt 38, right? Answer, with the same class, yes, that is correct. Question, how many Colt 38s are in this county on the streets? So I can't give you an exact answer, but I would think Colts probably hundreds of thousands, if not more, revolvers over the years. There are very well known and old company established company. Why would you repeat company twice? So when you get a general question like what you can't eliminate, you can eliminate 100,000 more guns in the case. You say, oh, easily, yes. Holy shit.
All right, so this is them refuting the fact that the likelihood that that those bullets didn't come from that gun. All right, we got that.
All right, so it says testimony then went to explore what other brands of revolvers had the same properties as a Colt 38 revolver. In closing argument, trial counsel noted that the firearms expert testified there were a large number of guns with the same properties as the petitioner's gun. Counsel argument was not that the expert had ruled out the petitioner's gun as source of the bullets. Instead, counsel's argument was that the bullets were fired from a gun of a class so numerous that the jury could not conclude the petitioner's gun was the source of the bullets. Counsel did not provide ineffective assistance on the issue. It says in ground 6B, petitioner claims that counsel was ineffective because there was no good or sound reason for his choice of defense. Petitioner argues that the counsel should have pursued a defense of self-defense or defense of others. The defense is incompatible incompatible with the defense that the petitioner presented, which was that he was there with a gun, but that he shot into the ground and the other person shot Esperanza. On this issue, the Nevada Supreme Court held appellant specifically argues that the trial counsel was ineffective to push the defense theory that someone else shot the victim rather than the theory that the appellant shot the victim in self-defense. The district court that the appellant failed to demonstrate the counsel theory of defense was unreasonable, or that the different story of defense had a reasonable probability of altering the outcome of the trial. We conclude that the district court findings are supported by the substantial evidence and are not clearly wrong. The appellant's own testimony in trial supported the second shooter theory of defense. He testified that during the altercation between his friends and the victim and others, he heard several gunshots. So he fired several gunshots at the ground near the victim. When he later learned about the bullet that hit the victim was not a ricochet, he felt relieved because I know that I did not point the gun at anyone, and I know that I was shooting at the ground. So I know that I did not commit the crime. He also testified following that his arrest, he told his grandmother and aunt the second shooter had killed the victim. Furthermore, other evidence at the trial supported his defense of a second shooter. His friend, who was one of the men involved in the altercation, told the police another man with a gun was present at the time of the shooting. There was also differing testimony from witnesses to the number of shots fired and the number of men involved in the altercation. Thus, in light of the appellant's own statements and other witnesses' testimony, the second shooter theory was not unreasonable. Moreover, appellant failed to demonstrate reasonable probability that self-defense theory would have altered the outcome of the trial. The evidence at the trial showed that his friends had initiated the altercation, and there was little, if any, testimony that other than that from the appellant indicating that he shot the victim in self-defense. Because the appellant failed to demonstrate the deficiency or prejudice, we conclude that the district court did not err in that claim.
So that was the Supreme Court.
Mm-hmm.
So that was an appeal. He was on an appeal. Yeah, it's a wrap. It's a rap sheet for that appeal shit. His best bet now. See, look. Let me just go to the back. Okay. Because all you could do is say what we would do in the situation, right? Best we can. If I clap somebody and they expire, and it's self-defense, I feel like it's a self-defense because that's subjective, right? And then you have to prove it. Yep. You feel me? Like capital murder. Right. So, if I do that, if I'm in that situation, sometimes dog cats gotta like stand on their 10, right? Even when you go through the other side. See, niggas want to stand on their 10 in the streets, but then when they get around, for lack of better terms. White people in the court, they get shifty. And it's just like, yeah, you shot him. He's dead. You're a murderer. No, I'm not.
Right.
I killed him in self-defense. Because either way it goes, somebody was going to go that day.
Yeah, it just wasn't me.
Because Young Keem is in there. What you saying? You rather it be me?
Right.
You know what I'm saying? Like, what are you talking about? See, now I need to know the scenario, though. Like, where were y'all? What's the altercation that led you to say that, I got to pull out and start shooting? It's self-defense. Was it some fades going on and it got out of hand? Or was it a crowd of them? Because right now it sounded like from all this that some pulled out the gun and shot this nigga. Now I know that's I know that nigga. That's not what happened. You know what I'm saying? Something else had to happen.
Right. So this bitch or nigga was a terrible fucking attorney.
So there was no guns found from the other side.
They don't know the dude. They can't.
No, not the other dude.
Oh,
the
no,
victim
I don't think the whole Esperanza shit, I don't think he shot anything. I don't think anybody, I think he was like by himself, nigga.
Was he the alleged target, or was he just an innocent bystander of some bullets going on?
I think they was getting into some shit with him by himself, and niggas might have just shot the shot.
So okay, guns. So let's try to make it make sense. It's Esperanza. It's the deceased. You got your boy Ja. You got and then allegedly a third party.
And then you got
Skull is there.
But they're saying that regardless of what happened.
Let me stop saying my nigga name on here, bro. It just fucked me up.
It's in here.
I don't care, but everybody ain't seen it. You know what I'm saying? I just
talked about this.
Yeah, I get it.
Public record, nigga. So basically, they're saying. I don't know if it was them three or more than them three. They're saying them three motherfuckers started shit with Jose.
That's their
something
story.
Gotta happen. That allegedly,
And then they
to
pulled
the
out-
court.
they
Yeah,
got-
allegedly,
they pulled
the
out
court,
the-
allegedly what the court saying
Right.
is they started the shit with Esperanza.
Was it some gang shit?
So, they're not saying anybody's
Well, I mean,
gang related.
I don't even know my man's to be gang. Yeah, like I'm just trying to figure out what. Yeah, that shit is man.
Said petitioner argued the trial
They're not
counsel
trying to raise some money for this
was
nigga.
ineffective in presentation of the second shooter theory, forced petitioner to present an unprepared testimony regarding the second shooter. The court agrees with respondents that the petitioner has not demonstrated deficient performance or prejudice, namely what else the counsel should have done and how what should have led to a reasonable probability of a different result.
You know what's sad? The court is the Supreme Court is a bad motherfucker.
Oh yeah.
They're telling you no, and telling you why they said
Why?
no.
Right.
But then they're telling you, nigga, had you and your attorney
Did better?
basically said, nigga, yeah, I shot the nigga, he died, but I ain't kill him. It was self-defense.
Yeah, you'd have had
And fought in that confine
you probably wouldn't be getting
and was
55 to
found
100.
guilty. This appeal would be this would be a lot easier.
Yeah.
You know what I'm saying? Then we can give credos to this, like you would have some reasonable fear of your life.
There's a long list of where they saying his lawyers fucked up. We just be going. Said petitioner argues that the trial counsel was ineffective for failing to hire an expert witness
Yeah,
to
that's what I said.
counteract the prosecution's
Man.
firearm expert. The court agrees the respondent's counsel did get the expert to agree that the bullets could have come from a large class of 38 specials, including the police revolver, including that the police recovered. Petitioner does not demonstrate what his own expert would have found. 6F petitioner argued trial counsel was ineffective because he waived petitioner's presence during some of the jury selection. The court agrees with the respondents. Petitioner has not alleged any facts showing that counsels performed deficiently by waiving the Jesus Christ, saying that wouldn't have changed the outcome for you, but ground 6G was dismissed and exhausted. So that means whatever you said on 6G, they said, nigga, whatever. Oh my God. Reasonable jurors would not find the court's conclusion to be debatable or wrong, and the court will not issue a certificate of appealability for ground 6. So they're saying, no, you can't appeal off that, nigga, because your lawyers did a good enough job. Damn, bro.
So, damn, bro.
Ground 7 contains claims of ineffective assistance of appeal counsel. A first appeal of right is not. Hold on. Petition claims the appellate counsel failed to present issues on direct appeal as issues of federal law. The court reviewed this issue that the petitioner presented on direct appeal. The court has resolved all those issues on the merits to the extent that a failure to present appellate issues as issues of federal law is a addressable claim of ineffective counsel. The petitioner has failed to demonstrate that prejudice. 7B was dismissed.
Wait, why you laughing, nigga? This nigga weird.
I'm not laughing, but they're just
You laughing?
niggas is just
Hey, but-
kicking his shit out like.
So no, that's the thing though, fam. Like,
and what
he's
if his
gonna have
lawyer
to-
wasn't shit? Like, what if all this is true and they're like, well, we don't give a fuck.
that
we
don't matter.
Give a fuck. We
that
don't
don't
give
matter.
A fuck.
What matters is how did he obtain his lawyer? If he got the lawyer,
No, I think
through-
it's court appointed. I don't think he.
so that's what. And see, that's another thing.
This is all court appointed.
He's getting.
Bro.
It sounds like this cat is being misguided, in his practice of trying to. Because the first thing he should be doing, that should be the grounds of his appeal, nothing else.
And then he
And to
tried
do that, you have to set. You gotta let your nuts hang. You gotta put your nuts on the table. Hey, white lady, you're good in divorce court, nigga, but you fucked me up over here, and I know you're getting paid hundreds of thousands of dollars by the government.
But bitch, you're fucking.
But you got to get the fuck up out of here. You're fired.
Yeah.
And then you got to go and do it and do a claim like, hey man, I need another point attorney, and this is why. Yeah. And then they got a laundry list of things she did wrong, the malfeasance, nigga, right? The malpractice. Look, boom, okay. These are the things, and then you stick to that. It sounds like he's trying to hold true to the story of, you can't say on one hand, I shot the gun either in the crowd or on the ground, and I don't know if my bullet hit the person or not. And that's what kind of, he didn't say that, but a person that's legally speaking for him said that. You know what I'm saying? So that sounds like a dub anyway. Like, but you my lawyer. You're supposed to be talking me up. What do you mean? You don't know. I don't. Even if I said that to you, but you ain't supposed to tell nobody else that, nigga. Like, hey. And when I say that, you're supposed to tell me, hey, don't ever say that again. Pick one. You shot in the ground or you shot in the crowd. Obviously, you shot in the crowd because they're not saying his bullet ricocheted. At the end of the day, dog, like you got to play the cards that's dealt to you, and it's just like you can't come out of this unscathed as a person that didn't shoot nobody.
His last reach.
I shot. This is me if I'm him. Mm-hmm. Look, unfortunately, I shot this dude in self-defense in fear of my life. That ends all the little bullshits of like, where the bullet? Hey man, I don't know. I pulled out. Shoot, where you shoot him at? That's probably what they'll ask you. And he's like, you know what? I don't even know. Like, how they gonna hold you down though if you knew or not? No, you know where you shot him. No, I don't. You know what I'm saying? Because I didn't hear no witnesses say, yeah, he put out a gun and shot him in the leg.
Yeah, none of the witnesses,
or shot him in the chest.
None of the witnesses that they say were there, even not Sco, said that they could concur, that they could definitively say Wadsworth shot and killed him.
And that's why it's hard to prove first-degree capital murder.
Right.
He got first-degree murder, bro. That's hard to prove because
55 to a hundo, bro.
That's proof. That's hard. That's
hard to prove without
lawyers. I mean, that's why they usually throw in a second degree in there.
Premeditated, nigga. That means I knew Esperanza from before, and I decided.
Now, do they have text messages?
Nigga. Right.
Do they have Facebook posts?
See that? Okay.
Is there anything going on between these two cats? I don't know.
That's what we need.
Because
Tobias to get on here.
Because that sounds crazy.
Because
dog,
if because it sounds like this was like beef that was already. Because if it was an instant on site thing and it was between 3-on-1, that's not something niggas just run across type shit. It sounds like, nigga, it was beef. Them niggas all met up and it sound like, okay, I'm not taking away from that theory. I'm not taking away from that. I'm not saying against that. I'm not speaking against that. To me, what I'm gonna add to that is it sounds like an altercation happened. Where somebody was getting got with.
No, an altercation happened. Mm-hmm. Whatever happened, it proceeded. Guns get drawn. Shit get let off.
But they're not saying Esperanza shot. They're only saying that
don't mean nothing.
I know it's not.
Because nigga, if it's going down and you moving a certain way, I ain't letting you get nothing off. I ain't letting you get to the gun. If I see your homeboys, nigga, talking like, oh, then they look like they running to grab something.
They're not saying any homeboys were there either.
But see, I'm just filling in the blanks. Mm-hmm. You know what I'm saying?
Let me see if I can find the initial.
I'm filling in the blanks because I know personally, nigga, 2 of the niggas that's involved in this shit, nigga, allegedly, according to them, and I don't see them. Even one of them I don't fuck with at all. Son's a whole op to me. But at the same time, I don't see him.
Was this here?
No, it was in Reno. Just pulling.
This has something in Las Vegas.
Well, it'll be in Vegas news too. Just pull it out, you know what I'm saying, on one dude.
And it was out here.
I don't know if it was out here, dog. I doubt it. I heard about that shit being up north. But it could be. I don't know exactly where it was. I actually thought it was happened by the barbershop.
If I could actually pull the shit up, I'd be fucking hating them websites. Hey,
but fam, that's crazy.
LVMPD.com. Get your shit together where a nigga can fucking go on your website.
That's the boys.
God damn, bro.
Don't nobody go to this shit. But no, like
here's the petition. Let's see if the petition
So the petition is a petition of like.
Oh, here we go. Here's a story of what they say went down in the petition. So it says at just 8. Damn, he's been locked up since 18, bro. I didn't even know it's been that long.
But see, since 2018?
No, at 18 years old.
Oh yeah, no, yeah.
So
Because-
at 18-year-old Michael,
That makes sense.
Michael witnessed his friends being attacked by a group of youths. So it wasn't just Esperat. See, this whole story's not telling.
It wasn't making sense.
So yeah, so now we know. Okay, it was nigga, some shit going down, an altercation.
So he
His
felt
attempt to stop the crime led the attackers to turning on Michael. As he ran away, he used a gun to fire at the ground to slow down the men chasing him. Tragically, one of the perpetrators got shot in the leg and died. Michael immediately turned himself in to the police. At 19-year-old, he was sentenced to up to 100 years in prison by an all-white jury. His state-appointed attorney, there's the answer to that. Now we have the definitive answer to that. His state-appointed attorney publicly disgraced Ken McKenna, stupid ass.
hold on, stop, fill me in. Who the fuck is that?
Dog, Ken McKenna is a fucking family divorce lawyer, nigga. He's a billboard lawyer, nigga. Not somebody fighting fucking murder cases.
Dog, look, pull his picture up. Let me pull his picture up. I think I know who you're talking
You've
about.
seen him on a nigga. So, publicly disgraced Ken McKenna failed him at every stage of the process. He later admitted in court that he misunderstood. No,
Why are they calling him public disgrace lawyer? That's what I was trying to get at. I thought that's what I'm trying to ask.
Publicly disgraced Ken McKenna of Reno
Disgrace?
because he's fucked up other cases. This ain't. So listen, let me finish this. He later admitted in court, this is Ken's statement. He later admitted in court he misunderstood the evidence in Michael's case, meaning he failed to follow a self-defense theory. Remember, we kept saying it wasn't Michael jumping back and forth. It was the fucking lawyer not knowing how to fight his case. Damn, bruh.
Damn.
He had only been involved in 2 criminal cases before Michael's. He was a divorce attorney. His tragic, ineffective counsel meant that Michael was persuaded by him to take the case to trial and was found guilty of first-degree murder, which means a willful, premeditated act. So you fucked up so bad as a lawyer that you got this nigga premeditated murder.
So that's why I don't understand when he was dealing with the Supreme Court. That wasn't being a focus point.
Because they kept saying that's where all the shit that I kept saying they kept.
And
throwing
does he
out,
still
throwing it
have
out.
that attorney?
But that's what I'm saying. They kept throwing it out and throwing it out. They're saying
Beat
that
this dog.
they're saying that none of this other shit, none of these things his lawyer did would have affected the outcome. Is what they're saying. They're basically saying the jury would have said what they said regardless.
Ken McKenna, attorney at law. Overview. Let's see. Nationally renowned and respected, Ken McKenna is a courageous and dynamic Nevada trial lawyer who always aggressively fights for his clients' rights. For over 30 years, Ken McKenna has provided exceptional legal service in and around the Reno, Las Vegas, and across the state of Nevada.
So
Damn, so it
not
says
only-
criminal.
He only had 2 criminal cases. He only fought. Nigga, we're in our 30s now. But we're talking about then. Then he'd only fought in 2 criminal cases before Mike's.
Yeah, no,
and he
that's
didn't give
crazy,
a murder
bro.
case. So not only was Michael given a 20,
Shit.
50-year sentence, mandatory sentencing law at the time meant the judge had no choice but to give him an additional enhanced sentence of 20 to 50 years for using a gun. Despite multiple appeals, the state of Nevada has continued to try to keep Michael silent.
So he had a gun enhancement?
Yeah.
That's crazy. There's no gang enhancement or nothing like that?
Mm-mm.
Okay.
He's already served 17 years, bruh. He's been in prison for 17 years already. That's crazy, bruh.
Damn. But yeah. It's a tough one, fam. That's a tough one because
Hey, Ken McKenna.
they got some shit.
Ken McKenna.
Well, fuck you.
Hey man, I don't know, bro. Like I'm just saying it like this, like
If you're you said it yourself. If your client's
No.
telling you self-defense, they're basically saying Mike should have took a plea deal and should have never even taken this to
hey,
trial.
fam, that's what the system is built on. You taking a plea deal.
No, Mike,
They get
but
offended
that's-
when
no,
you take it to
this
trial.
This was Mike's words right here. He's saying, nigga, he should have never basically even went to trial with this shit.
Not with that lawyer,
Yeah, nigga.
and not if they had.
He's saying, nigga, because you
So
know,
look,
'cause
okay,
probably
look,
his
stop,
plea- 'cause
stop,
if
stop,
we
stop,
think
stop,
about it,
stop. Let me
his
land.
plea deal was probably under the 50 years.
well,
He
we're not
probably
gonna
would have
deal
been
with
out
that.
by now on a plea deal. It's because if you say,
No, it'd have been at
this
least
was-
25.
But this is that was Mike who wrote that. That was his own words. So what I'm telling you in his own words, what he was just writing in that petition, is basically with him saying that him telling me to go to trial got me a murder one. I feel like he's saying, like, nigga, had I took the deal that they were offering me, I'd probably be out of prison by now.
But now this is a teachable moment. Because see, shit like Law and Order it's sexual. Seduces the American people, right? Movies and shit like that. There's niggas out here that really think a lawyer gives a fuck if you're guilty or innocent.
They get paid either way.
They might get paid more taking a fucking capital murder, first degree murder to trial in a city like Reno where you don't get that every day.
Yep.
And they got witnesses. Think about this. This is what the district attorney is dealing with. Now let's take it off that. You the district attorney. You slide in like, okay, we got this murder pop. Okay, what's up? What's going on? Any priors? No, he's not his first time killing anybody. He's not a habitual murderer and all that stuff. He's only 18, right?
No definitive evidence that he killed this man.
Let me lay it out. I'm just saying it. Hear how this would sound. Okay, so what we got on it? We got eyewitnesses. We got forensics. Right? Even though the forensics wasn't proven definitive, they passed it on like it was.
Yep.
Hey, not to mention, look, we got eyewitnesses, we got forensics, right? We got a murder weapon. We have a black male murder suspect.
Oh yeah, right. Yeah.
In motherfucking what they call it, the Mississippi of the West. Run every Negro out. Hey, bro, like, niggas used to always argue with me about it up there. Like, oh, bro, you be tripping. Like, it ain't. Hey, nigga, this is one of the most racist cities in the country. So now that you don't have, like, the thing is, I'm not, look, if there's a second shooter, fam, and the forensics
that
person.
That shit should have been investigated, bro. It
well, that's the
seem
thing,
like
though.
Y'all even.
Hold on. You're saying that. But, nigga, we dealing in real life.
Yeah.
It's a second
This
shooter.
ain't the first 48.
But it's the thing, though. There's another thing, too, though, and that we got to be dealing with. Some might know exactly who the second shooter is,
ain't
nigga.
Nobody gonna say
and don't want to snitch.
Because he might be a whole killer.
Fuck all that. Fuck all that romanticizing all that shit. That might be true. What I'm talking about is what like, look. Because what's the likelihood of you getting in a shootout with somebody and you don't even fucking know their name? I'm not saying a shootout against this person. Nigga, I'm talking about a shootout and y'all both shooting at the same thing. Or if it was it was just niggas pulling out their guns shooting because it was a big brawl or something.
Well, because here's what Mike never says is that he was being shot at. He said he only shot to get niggas up off his heels.
But see, that's where the stories change. Because on one hand, it was saying that, like, nigga, I was in fear for my life. It was self-defense.
Well,
I'm shooting.
If you're getting chased by 12, 13 people and it's just you, that's
Okay.
a deadly situation.
Okay, so they saying, so son's running. Son's getting chased down. Let me land. I'm trying to make sense of it. I'm trying to make sure I understand what you're saying. He's running.
Yep.
They chasing him. He pull out. Bim. Did he just let one shot off?
No, he let off several. But
Let off several shots.
Like this. Not even looking. He's running. They're saying he's shooting like this is why he's hitting walls and shit. And he don't know what he hit.
The sad truth is, when you're dealing with a person that went to law school and became a judge, do you know how fucking reckless that sounds? Hey, to the people that actually go to jury duty, that actually go, like that don't come up with an excuse, that don't be like, I got to go to work, that actually just go. I did too not too long ago. I mean, I don't want to talk about it on air. But you get what I'm saying? So you do all that. These are the people that are hearing that. See, to me and you, it makes sense.
Hey, Tobias, shout out to you for this topic, bro.
To me and you,
kind of close.
To me and you, it makes perfect logical sense. First off, to have a gun in your person, right?
Sure.
But that's something that black men have never truly been permitted, even though we have the legal right to do it. So when a young black man has a gun, it's automatically thought in a criminal sense.
Are they giving him a gun enhancement because he's illegally in possession of that gun? That's my.
He's in Nevada.
But if it's not registered to him, you're legally in possession of a firearm and you shot at somebody with it, that's probably what got him his enhancement for 20 to 50 years. Because think about it, if that's a legal weapon, they're not going to give you a gun enhancement. You shot your legal weapon at somebody.
Well,
No,
stop. Where does this happen? If this happened at a mall or at a public place where people like a public, that's what I'm saying.
Find the case.
But think about it, because if it happens in a public place or near a school or shit like that, because sometimes nigga, you could just be in the hood, just in the neighborhood or something, but the school's on the corner. And niggas pull up and shit go down and you get the dumping.
My opinion, I think his gun enhancement came because it was illegal. It was a legal firearm.
But they would say that that's a charge too. They would be like, illegal possession.
I think we didn't see his charges. It didn't say what it was guilty of.
Yeah, see, pull that up. I don't want to see that.
Just
because, yeah, dog, this shit sounding. It sounds tough,
because
bro.
in Nevada,
but then it sounds like he might have some light. But the only way he has that light is if he has the funds and the.
If he was a legal gun owner, I feel like it would have went. It would have had to win a little different because it's all right. He could then it would have gave him a strong. His lawyer was still an idiot. He was still.
Hey, bro,
his lawyer's
I've been telling niggas.
Get your fucking.
Only niggas that should have throwaway guns is niggas that don't live in Nevada or Arizona. Why the hell would you have a throwaway and you live in Nevada where motherfuckers be having Glock 9s in they hip at Walmart in front of cops? Like, you can legally have a burner.
Show me. I see the free Michael Wadsworth, but show me the case. Wadsworth versus Williams. Here we go. This is the one I just read. Show me the fucking case news.
Yeah, that's it. That's a tough one, boy.
I probably need to look up his name. Jose
you got to look that. And then another thing is, people don't like to do it. They do it though. They do it to Trayvon. They do it to all the a lot of victims of ours. What was this? The alleged victims or the deceased victims? What was his life like? What was his background? Was he in a gang? Like, does he have a violent past? I think all that should be called into question too. If you're gonna throw away a dude and just lock him up and throw away the key like that, like you need to know. Because if I say, yo, man, I was running, man, and they was chasing me, and I shot back, and the dude I happen to shoot and the dude that happens to pass away is a known hitter to the police and a known hitter to the authorities in this community and shit like that, that should have some kind of leeway in the way you deal with me.
What 17 years ago would be what year?
Nigga, I don't know. Hold on.
17 minus 22.
I'm thinking 2003, 4.
You're close.
Because I vaguely remember when this shit happened. It's like
2005.
Oh, shit. 05. Damn.
Why can't I find the fucking case? That's weird, bro. It's like...
Yeah.
Hold on. Fuck this, dude. There's too much, like...
Hold on. Let's just go here while you looking that up. It's okay. It's been proven. It's documented that he had an incompetent attorney, Ken McKenna, or whatever, or let's say this, an unexperienced attorney. How does an attorney not understand? Hey, fam, he kind of got a case, bro.
He does.
He kind of got a case. And I said what I said, but he do got a case, and that don't take nothing away from what he got a case, bro. Because if the attorney is saying that they basically screwed up, like, hey, we dropped the ball, but see, then again, I don't know if that's grounds for an appeal, because you kind of hire an attorney at your own risk, and unfortunately, in our country, if you don't have the means to hire an attorney,
this is crazy.
They don't care. They'll just give one to you. What?
This is his appeal court date.
Play it.
shit's like 30 minutes long.
Nigga, we've been talking about this shit for an hour and 5 minutes. Like, nigga,
Let
this,
me make sure. I will. Let me make sure this is.
and I should have already cut into the whole show. What we was doing, nigga, just ride it out. We do this for my nigga
They
Tobias.
don't even show this dude though, so I don't even know if it's his case or not.
That's his name.
And it says
no, but
versus
that's versus Brian
Williams.
Williams,
No,
right?
but it is. It's Mike versus Williams is the name of the case. And I think it's because you're not fighting Esperanza. He's dead. You're fighting the defense. It's whoever the defense attorney is.
So I thought it would be Mike versus the state of, like, you know what I'm saying, Nevada.
I don't think the
what's
state of
his name?
Nevada is fighting him. Or I don't know. Well, it's the United States of Appeals Court. So this is appeal.
Different claims there, Your Honor. One is the rejection of his proposed instruction with respect to the consideration of conflicting evidence. That goes to whether or not the jury was properly instructed on
This is his case.
innocence. There's no challenge here to those instructions. Those instructions were correct under Nevada law, and so
This is his
the
case.
rejection of his instruction on the conflicting evidence stuff, there's no error there at all. Now, with respect to the Dixon issue, which is a separate issue about whether or not the jury was properly instructed on self-defense.
Jesus Christ, that shit was
What?
on. Hold on, I need to pull it up on. I hate the fucking internet.
Pled in the petition, Your Honor. So as part of the
Wait, let's start this from the beginning.
Good morning.
good morning, Your Honor, Martin Novi on behalf of the petitioner. May it please the court, I'd like to reserve 3 minutes for rebuttal, please. Your Honor, in this case, by failing to prepare and investigate in anticipation of trial, failing to understand the evidence.
That's crazy. You go, hold on, let me go here because I don't have to be on my phone. I can just play it. That's crazy
What?
that we can see a nigga's appeal.
No, that's, nigga, it's America. Shit.
I just didn't know they did. You could see like I understand like motherfuckers who was like famous and shit.
Nah, bro. That's how the district attorney out here got Floyd Mayweather to plead to that shit. That he basically was like, nigga, I ain't do. And we gonna put your kids on stand and everybody's gonna see that shit.
I'd like to reserve 3 minutes for rebuttal, please. Your Honor, in this case, by failing to prepare and anticipate,
Almost.
prepare and investigate in
The whole
anticipation
Pepsi
of trial,
moment in this motherfucker.
failing to understand the evidence before him, failing to pursue a self-defense theory of defense despite compelling evidence to that effect, and by proffering an unconstitutional jury instruction, trial counsel abandoned Michael Wadsworth, my client, and left him at the mercy of the state's case, leaving the jury no option but to find him guilty of first-degree murder. Now, under Strickland, as you know, trial counsel has wide latitude in making strategic and tactical decisions. But the record in this case reflects, and I think conclusively proves, that there was no strategy or tactic involved in trial counsel's failure to present a self-defense theory of the case. In this case, the evidence was substantial prior and during trial that a self-defense theory was not only meritorious but needed.
Well, let me take you back a little bit. You argue pretty vehemently about what counsel did bad in the state court. Let's talk a little bit about your motion for leave to file a third amendment complaint. District court found it was not timely.
Yes,
Why
Your
was
Honor.
it timely?
Well, it's not timely, but it relates back.
Why does it relate back?
Well, it relates back because there's a common core of operative facts.
Well, just a minute. Even if the
Here,
court
you know
had
what?
determined it timely.
Fuck am I doing?
Doc, I ain't even gonna lie. I just wasn't gonna get on you about it. You know what I'm saying? Like, bro, I was just gonna let you do your thing. I'm like, bro, why don't you just pull it up so the people can see? That's crazy, fam. The reason why it's crazy to me is because I'm like, dog, but I guess it just comes down to the
Timely.
rule of law. Like,
Why?
I don't. It sounds like it would be a reason solely to grant this kid an appeal. Like, nigga, here's an appeal. Refight your case.
Doesn't that
with an attorney that,
third amended
you know,
petition
but then
have
you
to be
get
dismissed because it was
a
unexhausted
do-over, so to speak,
claims at
lack
the
of
time
better
it was filed?
terminology, because your lawyer.
Well,
Yeah.
although they may
you
have
get
been
a mistrial.
unexhausted.
Well, if they're unexhausted,
They'll have to retry
then
the
they can't
whole
relate
case.
back.
Nigga, I don't know, bro.
Well,
Yeah, no,
I
that's
know
how,
a lot
that's
of
how
niggas that
that
then went to jail for a long
No,
time
but that's
for
how
having
that
a bad
works.
attorney.
If you can prove to a court of law
That your
that your
attorney
attorney
was
was a
incompetent?
dumbass, they have to give you
Then
another
after
case.
the
They have to give you a
district court
whole
says
nother
it
trial, a
isn't
whole nother
timely,
lawyer, and you have
then
to
you're
fight your
saying,
case
no,
from
they
start
would
to
have
finish
related
all over
back.
again.
Well, see, this is my
That's
thing.
just like giving
But look at the
don't
nuance
really
here.
talk
That's like
about
giving you
why.
evidence
Look
to
what
a
the
case.
attorney
Relate
admitted
back
to.
when they're
He admitted to
unexhausted.
arguing the wrong
Problem
argument.
is that contained unexhausted.
Nigga, that's
at
like
the
saying,
time
okay, a
filed,
defensive coordinator was
and if
like,
they're
shit, I should have ran the ball.
unexhausted, They
Right.
have to be dismissed.
That
anyway.
ain't grounds for being.
Your Honor,
That
You
no,
admit
but the
they're
thing is,
unexhausted.
that's what this
no,
shit is.
Your Honor,
Oh.
at
No,
the
no,
time,
it is. That's
the-
still
He proved
well, at the
confidence.
time the motion
Well,
was
I don't know if
filed,
he's
at least
the
one of the
confidence
claims
is
was
the word.
technically
no.
exhausted.
You can
That would be the claim.
He just
that-
lost.
No, you
Why
can
tell
prove him
us
to be
why you say
incompetent.
technically?
I know that, but I'm
Because I
saying,
think
is that the
that's pretty
case here, or did he just
Which
lose?
one
No,
and why
he-
was it
he
Did
absolutely
he just
did.
lose and we like,
Ineffective
damn, you
assistance
weak, you didn't know that?
counsel
Or is it
for
one of those things where it's like,
offering
No,
an
no, no,
unconstitutional
no, no.
grossly-
jury
He
instruction
grossly
was
fucked up.
technically exhausted.
Because
It
he
was
could have
technically
easily
exhausted because
got this case
although
walked
there was
back
no
to
remedy
almost
in
and then,
court,
and then I'm saying
there
it's
was
been
no
17
waiver
years.
To the default.
You definitely
Under
went to an
Martinez
appellate
v.
court
Ryan,
at 5, right?
There was
If not
cause
10,
and
if not
potentially
15.
It's
prejudice
because the court
to,
is this is where I feel like
argue
the court's
that
fucking
case.
him. The court's
Your
deciding.
Honor,
to
moreover-
decide.
Did you argue that in your brief?
We feel like
Well,
he did
the
it.
district court did not deny our motion
That's
for
what they
leave to
keep
amend
Well,
on the
saying.
basis
I'm not
that the
saying
claims
that,
were
but what I'm-
That's what
exhausted.
they keep saying.
Right.
They
They
merely
keep saying
stated that
that
the claims were
Because-
untimely.
Well, even if you
Our
say he
argument
was
today is that the
incompetent,
abuse its
they
that the
saying
district court
that
abused
that
its
would have
discretion
not
making
changed the
that
jury's
finding
mind.
because they do in fact
Every
relate
time
back.
he goes to an appeal,
Are we
The standard
talking
that
over
was
video?
imposed by the court
Okay,
in terms
okay.
of what the operative facts need to be is extremely narrow, and Your Honor, in this case, inapplicable. If you look at the cases that were cited in all briefs, whether they be Males, Tiller, Nguyen, or Schneider, in all those cases, the operative fact is never determined to be the actual act or omission by trial counsel that results in the ineffective assistance of counsel claim, but it's rather a much broader concept. And that is consistent with the language in Rule 15 and the cases interpreting Rule 15, which talk of occurrences, conduct.
Okay,
I
I've
thought
heard
you-
your. Oh, go ahead.
I'm sorry,
Did you
but
have
I
a
think you-
question about that?
Yeah, because I thought you argued that you didn't previously raise this whole line because of Dixon.
Well,
Is
Your
that
Honor,
right?
Well, Your Honor, there's no good reason why this wasn't previously raised by state habeas counsel or our office. However, the question is whether the claims relate back. And they do, unless you impose, again, an extremely narrow and constrictive interpretation of Rule 15 and what it means, what an occurrence or conduct mean. And that's not the case here. If you look at Schneider, which opposing counsel cites favorably in his brief, Schneider did not...
I guess I just want to pause here and ask you, was there any reason or why you failed to raise these claims that you're talking about regarding the self-defense instruction earlier than the third amended complaint? Did you, because it doesn't seem like you specifically raised that until the third amended complaint. I'm trying to figure out why.
The claim I'm referring to was asserted in the third amended petition, yes.
I know. Was it raised previous to that?
Well-
In the second one, in the first one?
Okay, so the instruction is actually asserted as in the original amended petition, which was timely. It was noted as part of the insufficiency of the evidence claim, which was claim number 1.
So it really wasn't pled. It was just a notation in another claim pled.
Well, it was noted and it was pled. It was noted as part of the insufficiency of the evidence claim, and it was pled or strongly alluded to, I would argue, as part of the ineffective assistance of counsel for his choice of defense claim, which is claim 6B in the originally amended petition. And
Sorry, I didn't mean to interrupt you.
no, Your Honor, it's quite okay.
I was just going to try to go to this thing about the refusal of the instruction.
Yes.
It seems to me that under Nevada case law, courts are permitted to refuse to give instructions if the jury is properly instructed regarding reasonable doubt.
Right.
And I've found no United States Supreme Court decision that says that is clearly wrong. So at that point, if in fact there is no Supreme Court decision that suggests that is bad law, then how can I give you relief?
Well, Your Honor, you're correct that you have to assess the totality of the jury instructions that were given to the jury.
Well, in fact, and so therefore, at that point, it is, as long as I can find that the jury has been properly instructed regarding reasonable doubt, which is exactly what the Nevada Supreme Court has said, then I'll have to not help you, right?
Well, Your Honor, and that takes me back to the unconstitutional jury instruction. The jury was not properly instructed as to
Well, I understand what you're saying, but all I'm saying is Nevada law is pretty clear as to what they have to do. And Nevada interpreted their own law saying it was just plenty good, and that those were very good reasonable doubt instructions. And the Supreme Court has never said the Nevada law is wrong. So me giving it deference now, I'm stuck. That's what I'm trying to get you to help me with.
Well, Your Honor, as I was stating, if you look at the totality of the jury instructions, you'll see that
But Nevada says the totality does what's needed to be done.
Right. Well, we believe that the Nevada Supreme Court
was wrong,
unreasonably interpreted
all right.
U.S. Supreme Court law.
Okay, so let's move to the next. How about the Nevada state courts? Did they unreasonably determine that Wadsworth was denied ineffective assistance of counsel? That's the next question.
Yes, Your Honor.
Okay. Was there? It seems to me there is meaningful evidence to support a second shooter theory, right?
Yes.
Well, then how can it be clear that relying on a different defense would have produced any different result?
Well, Your Honor, because there was substantial evidence of...
all you're suggesting is I've got enough evidence to go to the jury on a different theory, but there's absolutely meaningful evidence that went to the jury on the theory presented. And all you're saying is, let's second guess this, everybody. Because you had some other theory you could have presented, that's the one you should have done, and you should have ignored the second shooter theory.
That's not our argument, Your Honor. In our brief and in our pleadings, our argument is that the defenses were not inconsistent.
Well, but the second shooter theory didn't work. It was your better theory.
Right.
You know, and so I think precisely it's not the type of thing, it's sort of like if you present an alibi defense,
right,
but then you want a self-defense theory, and the alibi defense doesn't work out, well then you can't really claim there really wasn't any evidence of self-defense. That's the problem. But now we know, in hindsight, that the second shooter theory didn't really resonate with the jury. But that's not really you can't build a case for relief on the basis that your theories didn't work out. You have to show that there's some evidence that self-defense was there, and I'm not seeing any.
Our theory is that counsel was ineffective in presenting his theory of defense, both a second shooter and by failing to present a self-defense theory of the case.
But at some point, you look ridiculous. It's sort of like if you say, well, my client wasn't there, and I've presented all this evidence that he wasn't there. But even if he was there, I think you should look at, you should consider self-defense.
Well, I don't believe that is analogous to what occurred here. The evidence at trial was that my counsel shot a gun. He maintained that in his conversations with counsel at all times. And based on evidence that was vague or flimsy at best, and despite evidential limitations, counsel went alone on
No, but counsel, the the criminalist or the ballistics expert was really kind of a wash. And that was part of something else that was raised that, he said, well, I can't say it was I can't say it was the defendant's gun. It might have been, it might not have been. So that's good, and that supports the second shooter theory.
It supports.
So it wasn't unreasonable for him to come up with that.
It was unreasonable for him not to present a second self-defense theory of the case, Your Honor. And that, again, I believe that is.
Do you want to save time for rebuttal?
Can I ask one question?
No.
I'd like to
go ahead.
So I just want to make sure, what do you think was actually pled then regarding the self-defense jury instruction? I know there's a lot of overlapping claims here, but
yes.
I want to know what you think was actually pled regarding the self-defense jury instruction.
Do you mean in our brief?
Yeah, in your amended.
Okay, so in our timely amended petition, it was pled that counsel tendered at last minute, 11th hour, self-defense instruction, and that was pled as part of the first claim for insufficiency of the evidence. But more importantly, and this is the claim that I believe it relates back to, it was pled that counsel was ineffective in failing to present a self-defense theory of the case. And as you know, Your Honor,
but hold on, wait, though. So, correct. In the original petition, it says that counsel belatedly brought it, the self-defense jury instruction, not that it was brought incorrectly. Do you agree?
I agree.
Okay. So I just want to make sure we're clear on. And so I guess I'm trying to figure out, because your brief focused on the Dixon, or that it was because of Dixon that it's what brought light to this for you, to bring up this sort of new claim or version of this claim. And it seems like you're only talking about Martinez in passing here in oral argument. So I'm trying to understand what it is that you were arguing in Dixon, or why Dixon was so important to you.
Well, it came to light because the state argued that there was lack of prejudice as the instructions were not faulty or incorrect. They argued that in their answer to our petition for habeas. And that's what caused our office to come to the realization that there was an unconstitutional jury instruction. So it was argued as part of the prejudice element by the state. And the reason why it relates back to our ineffective assistance of counsel claim for his choice of defense is because a choice of defense is redundant, is insignificant without properly instructing the jury as to the law of that defense. Without a proper instruction, you might as well not present any evidence of that theory. So that's why it relates to, or it arises out of the same transaction or occurrence as a timely, originally amended claim.
But you said that happened in state habeas, in the state habeas petition? You were just arguing right now.
Yeah, no, as part of the federal petition.
I guess I'm just trying to figure out, why is all this coming up in the third amended complaint?
Well, again, it was argued as part of the prejudice prong by the state, in the sense that they argued that there was no prejudice because there were no incorrect instructions pled in the petition, Your Honor. So as part of the prejudice prong to our ineffective assistance of counsel for his choice of defense claim. And we replied to the answer noting that there was, in fact, an unconstitutional jury instruction.
And what's going on with this jury instruction? This is not the first time I've seen this jury instruction. Is there a bad model instruction out there or on the self-defense?
Well, there was until 2014 when this court ruled that it was an unconstitutional jury instruction. And it's a troubling instruction, Your Honor, because it prevented the jury from finding Mr. Wadsworth guilty of anything but first-degree murder as a result of the instruction on malice.
Thank you.
Did you have an additional question? I'll wait. All right. Well, we've taken you over time, but I'll leave you 1 minute for rebuttal.
Thank you, Your Honor.
Good morning.
May it please the court, Jeffrey Connor on behalf of the respondents. Good morning, Your Honors. I think I'll try to get to some of the questions that the court has answered, but I think I'd like to start by first addressing the issue respondents raised with respect to the certificate of appealability in this case. Gonzalez versus Dowler is clear that the 2253C standards for granting a certificate of appealability are mandatory.
You challenged the sufficiency of the COA only after it was granted, but did not object when the application was filed. So why should this court consider your challenge in light of Gatlin v. Madding, where we held that when the state fails to file a timely response to a motion for a COA, it is foreclosed from later arguing the narrower.
All right. So it's from my, and I'll wrap it up with this, man, but it definitely, in my opinion, seems like he had an attorney that either one didn't give two shits, right? Or secondly was just, I'm not going to say incompetent. But he wasn't
fit for a murder case.
He had just started doing, becoming a trial. He had just became a
you
trial
got
lawyer.
Two criminal
he was in
cases
he was a family court lawyer.
And this was fucking murder.
This is where I think that John is getting the raw deal, in the sense that his whole shit is basically, he got the outcome he got from following the guidance of an attorney that the state or the government provided for him because he couldn't afford one on his own.
Mm-hmm.
And so you basically got him a bad lawyer. And now he's held accountable for the bad lawyer. I guess the bad part of that, and I know you don't like when I say the words devil advocate, but like the other side of that would be, hey, they never promised you a good lawyer. But they do promise you, what's the word? Not an accountable, a capable attorney. Like, you know what I'm saying? Like, I don't think just because you're an attorney, your name and number should be in the hat to call if someone needs a public defender, and you haven't tried a significant amount of cases. You don't have a significant amount of experience. I don't know if a public, and it's a difference. You have the public defender's office, right? And then you have a court-appointed attorney. What he got was a court-appointed attorney. I'll give you the quick example of a difference. George Zimmerman. He got a court-appointed attorney, but he got one of the dopest defense attorneys in the country. $1 million attorney he got. So that comes with built-in resources. Like, we already have an investigative team that we use. We already have somebody in the forensics department. We already have somebody in the police department that does this. We already got somebody, a couple of media outlets that we deal with. You know what I'm saying? They're able to provide an adequate defense, a more than adequate defense. In his case, I don't know if it's through his family or whoever his support system is. I think it's a situation of not knowing, of being ignorant to the matter. Like, yeah, okay, they got him an attorney. That's cool. We don't have to pay for it. That's good. He got an attorney. And the attorney says that he has a good chance of beating this case. And that's all they have to go off of. You know, it's a raw deal, bro. Like, but that's the American justice system in a nutshell. It works better for the rich, because had he been a kid with money with the same circumstances, there would have been every expert that they used against him. There would have been an expert to muddy those waters or to contradict the statements made, because they're all subjective. You can go get 30 eye doctors to examine one eye, and they come back out with different analysis of the ailments plaguing that eye. So I just think that, like, he definitely needed a better defense team.
It seemed like he got one, but just
now it's too late.
Too little, too late.
It's like the movie, you feel me, where it's like the good lawyer got the case and they're racing against time, and it's just like, nah, man. It's like the Tukey Williams story or some shit. Like, you know what I mean? But what I would say to anybody supporting this dude is like, yo, definitely you want to reach out to the Innocence Project. My mother just wrote something in the comments, even gave a name as a reference to someone in another organization. But there are organizations that scour over cases like this, where there are possibilities and stuff. You know, where there's nothing left, and they have the resources to go get the forensics. You know what I mean? And counter those. They have the resources to go pull up those witnesses. First off, hey man, just like a prostitute and former recovering drug addict isn't a good witness when she's the only person that's seen a cop kill a black kid or kill anyone. Hey man, some of those witnesses, who are these witnesses? Are they friends of the deceased? What are they doing? What's going on? They didn't seem like none of that vetting. It seemed like the witnesses said what they said, and they just ran with it. Like, okay, we got witnesses. This is what happened. You know what I mean? All the while saying that Sko, what he said is irrelevant.
Yeah, pretty much. Like,
you know why? Because that attorney didn't make him relevant.
Yeah.
He should have been on the, should have had that boy on the stand. Like, no, we was running. It was dangerous. Like, we was in fear for our life. This is a tragic thing. But yeah, man, like, and then it's like, it's hard to comment on that as far as not knowing the location it happened at, not knowing exactly what jumped off, what kind of, like, you don't even hear, they didn't even report on any of the rumors of what caused this. Something caused it. Them cats ain't gonna just start shooting for nothing. And if you're gonna shoot the spot up, why would you run with your back turned and shoot over your shoulder or under your shoulder like that? If you're gonna air that thing out, then you're just gonna stand firm and turn around and ring them things off.
Right.
So I don't think that he did that out of just nothing. I think he was just running for safety. You know what I'm saying? You guys is about to get jumped. You know how they get down over there. Right. They was about to jump them niggas or whatever. They was outnumbered, took off running, and he probably did let something off like, yo, bag up. You know what I'm saying? Jesus Christ. But damn. They bagged Shorty, man. They ain't this nigga. What he doing, 100?
55 too.
So how does that break down? So after 55 years, he gets to go see an appeal?
He gets to see parole.
And see if they're going to parole him? Oh, he's eligible. He's eligible for parole at 50,
So what we don't know, though, are these running consecutively or are they running concurrent?
But then again, it's just like...
If they're running consecutive, he's looking at 100 years. If they're running consecutive, he's looking at 50. Before appeal or before parole.
So shit, he's 17 into like 55? Shit. So on paper, this cat got over 30-something years left to serve?
Yeah.
I don't even like this nigga, bro, but that's foul.
Yeah.
That's foul. What I would suggest, dog, especially Tobias, because, I mean, you the one that put us up on this topic. This is some shit that I would never have spoken on. But yeah, fam, I don't wish this on nobody. I mean, this is a person I literally could definitely have defined as an enemy of mine. And so when it's real as hell when a nigga be like, yo, I wouldn't wish this on one of my worst enemies. I wouldn't wish it on him, man, because you look at the age and then you look at the consequence. Now look, if there's, because now let's, if one of my loved ones is deceased, I'm not trying to hear none of the shit we talking about.
Right.
So I don't mean no disrespect to the family of the deceased. I'm only speaking to the trajectory of if it's possible that he's not the shooter. Now, another thing is, if that's one of my loved ones, fam, I don't even care if your bullet didn't kill him.
You shooting at him.
Nigga, you was shooting.
Right.
And your shooting probably caused other shooting. Y'all was shooting. Y'all shooting caused my baby to die. Right? It's a fucked up game, man. And it's like, as I get older, I'll be like, damn, bro, why are we the only so-called first world nation that literally kills like each other? They try to put that shit on the black community, but Americans are sick. We kill each other. White Americans, Asian Americans, Hispanic Americans, Black Americans kill each other. And it's just like, damn, bro, like, It like because in London, London's very violent too, just like America is. There's just not gun violence just like that. So they stabbing each other up, beating each other up with billy clubs, and keeping it pushing. There are deaths and stuff like that, yeah, but not nowhere near. Like if you just go right now and look up like the deaths in this nation versus other nations, bro, on a yearly scale, the shit is astronomically crazy. How, on one hand, how the hell is 3,500 Americans getting murdered by guns, and all in the rest of the world combined, it'd be like 27.
Right.
Unless they just lying about those numbers, but that's crazy to me. It'd be crazy, bro. It'd be like 300. The rest of the world combined, it'd be like 300 murders. America would be like 3750. And they blame Chicago, they blame certain areas, but it's not just that. Like this shit happens everywhere, folks. But yeah, so Tobias fam, I hope we was able to shed some light on it, bro. I don't know if condolences is the word, but peace and love, man, and good energy, dog. I'll pray for your mans, bro. Like I hope that that works out for him. Like I said, the Innocent Project, you need to tag. Unfortunately, we don't have a big enough platform yet, but we'll do what we can. But we need to get this. You need to get this story out to some of these outlets, because right now, more than ever, the people of the United States are willing to hear the story and shed some type of sympathy and understanding on situations like this involving someone potentially murdering or killing another person. And that's just because they know people are tired. Good-minded, non-black people are tired of waking up, turning on their Facebook on a Saturday morning, looking at their grandkids and be like, oh, this guy that was convicted when I was a sophomore in high school just got out and he didn't do it. You know what I mean? So the people are tired of hearing that shit. So I would push that narrative. Local officials, nobody in Washoe County should be able to get a vote. If he got supporters out there that's gonna ride for him and be like, yo, we want y'all to look at this case. I don't think no one's arguing that he shouldn't be in jail. But I think that 17 years might be fair. You know what I mean? That's a long time, bro, to be in jail right now. So, especially if you didn't kill anyone in malice, like you literally was just defending yourself in fear and running away in fear and turned around and shot, just as a like, hey man, they catching me, they gonna catch up to me. You know what I'm saying? So, I don't know, bro. They don't have no surveillance footage, nothing like that, huh?
It said there's video footage of what happened.
Damn. So what?
How they know he ran away is how they know he dumped the gun and shit.
I thought that was just from the witnesses.
I don't know. Maybe
Yeah, I think that was the witnesses that said that. Because I'm like, fam, if they, what are we talking about?
But
they know what happened if the shit is on camera.
Let's talk about some other weird shit I just came across. Shout out to Mike. Hopefully somebody finds some new evidence in your case and they can reopen it and you don't need it since you exhausted your appeals. That's all you got now, other than parole in 30 years. Why is Lil Uzi Vert bleaching his skin?
Who?
Lil Uzi Vert.
That's the same dude that put the
diamond
in his forehead, right?
Bleaching his skin now. Fuck is wrong with people?
Self-hate.
Like for real.
Self-hate. And then what I'll say this is, what's wrong with the world that'll make a man want to feel a need to bleach his skin?
Right.
What's wrong with the industry that a man is in? Because see, you don't know the management conversations where it's like, yeah, you had the deal, but they felt like you were too dark-skinned.
Dead ass, right.
Oh, yeah, you got the deal. I ain't going to give no deal like that to you. You too dark-skinned to get that. Right. You got to be like light-skinned like so-and-so, nigga, to get those type of deals. And then you just see that person getting those deals. Now, it's weak as fuck if you ask Hakeem. but I'm a proud foundational Black American. I'll die that way.
Oh yeah, that's weird. It's all the way.
But at the same time, I'm starting to see it. When you look at some of these Dominican and Cuban brothers over there that's playing soccer and baseball, and they're doing the same thing, go read into the treatment that they're receiving for having darker skin. And if you're telling me now that I'm a millionaire, nigga, and I can further my millions and not be treated so harshly by using this cream for 6 months,
Right.
some people are just that. They're just that fickle. They're just that. You know what I mean? They don't have that. Some people don't understand that, like, you know, the way that I was created, the way that I came from my mother's womb was my perfect self. But that goes into some other shit, because if we gonna pick on Lil Uzi, hey man, there's a lot of motherfuckers that we could pick on. But some of that shit is cool though. Because there's a lot of motherfuckers walking around here with asses that ain't theirs. Lips that ain't theirs, cheeks that ain't theirs, fucking all type of shit that ain't theirs. You know what I mean? So I am knocking it, but I'm not knocking him. I'm knocking the decision. Like, fam, you became Lil Uzi the same way you were, the same little dark skinned boy you was. You came that way. You know what I'm saying? Yeah, that's nuts. Hold on, man. Let me get to a couple of these joints before we get up out of here, because that case took a little minute, but that was some wild shit.
Happy late birthday to the great Jay Dilla.
Damn.
February 7th was his birthday.
I wanted to go to a Jay Dilla day so bad.
Today's the day he passed.
Yeah.
I remember when I called my brother and told him
we
that,
ain't
bro.
play no shit, bro. We got ambushed by this.
I just read something.
No, but you know what it is? Now that we can play shit, we need to start playing more shit. You see, you heard that push? That Diet Coke? That shit hard. 88 keys and you on the beat. I had a question. I'll let the people look it up on their own, man. It's I've seen people running with this narrative that you know, that they're throwing out, oh, the Biden administration is giving people crack pipes, legalizing, you know, crack, or giving people crack, you know, which is, I guess, somewhat true that there's a initiative going on. This is my thing. I looked at that and said, is the Biden administration, if that's true, right, if they're distributing and getting behind, because they've already been doing this for years, if they're getting behind that on a federal level, like, hey, we're going to help fund some of these programs that distribute clean needles and stuff like that to prevent the spread of, you know, different diseases and stuff like that.
Right.
Okay. You can agree or disagree with that. That's fair. But I thought when I heard that the Fed's getting in on that, it makes me think, are they moving closer to legalizing drugs? And that's something you hear in the background a lot. Is the legalization potentially of all drugs on the North American?
Well, they've legalized it like somewhat in Oregon.
Well, that's Oregon's a trailblazer in that regard. I thought they legalized everything.
They did for personal consumption.
Yeah, because why criminalize someone that has a sickness?
Right.
If you're going to classify addiction as an illness, nobody goes to jail for having cancer.
Right.
or AIDS or hepatitis or syphilis, you know what I mean? Yeah. Schizophrenia or anything like that. You don't just lock niggas up that got multiple personalities. You help them deal with them. You get what I'm saying? I think that it'd be cool to make, if your addiction becomes criminal, to make you go to rehab. Like, I could see like a jail-centered rehab facility.
Right.
Where you ain't leaving. You know what I'm saying? It's where you sleeping at.
Doing hella shit.
And you got this much time, so you might as well get clean. If not, you can go back out, do what you do. It ain't illegal to get high. But if your ass get caught stealing and you're high, it's a problem.
You're going to have to.
You right back in
there.
Go
sit it down.
Right? Because that way when you go into jail, you're not going to jail to get broken down as a human and thrown back in society. Yes, no, you're going to jail, you're getting detoxed. And not only are you going to get detoxed, you'll have the therapy there. You have all the people that work in those fields would have employment in the prison system. You know what I'm saying? They'd rather have a motherfucker that played football in high school, nigga, and didn't make it in college go be a prison guard, nigga, and that's your rehabilitation guy. Like, These niggas letting niggas do you dirty over Snickers and playing gladiator sports with you and shit like that. Like, you know what I mean? They not really built to like help you rehabilitate. Some of them do great work, I'm sure. That's ill to me. But I thought that was, you know, what do you think about that? Do you think it's a bad idea to legalize drugs in that capacity? Like, or do you think it's a stretch?
For legal consumption? Nah. Because think about all the people right now, the people who don't sell drugs, all those people who are users who are in jail for nonviolent crimes right now.
Yeah, that's what I'm saying. They're flooding. Their majority of the jails are addicts. You know? Or what's the percentage of those that are in jail based on doing crimes to feed their addiction? You know what I mean? Like, say you're a functioning addict, you got a job, you're doing all type of shit, but you jonesing real bad, I guess, and you know someone's like, oh man, don't trip, we just gonna go in here. My boy said that he gonna give us this, and then we gonna take it over here and sell them, and it's a sting operation going on that day, and y'all get caught up. You know, yeah, you did something criminal, but it wasn't based on anything criminal other than the fact of I'm doing this. I've lost all judgment, and I'm doing this because I'm addicted to a substance, and this is the only way I see logically that I can get it, or it's the only way I can in my mind I can figure out a way to obtain it. It's just a kind of weird thing that we do. It's a weird thing that we do. Or what about this? If you went to prison for drug offense only, you got to come home on the weekends. Like they do over there in Europe and shit like that in certain places.
That ain't never going to happen because that means that's 2 days out of every week that the prison's not getting paid. They're not making money off your barcode.
They're not making money off your imperfection.
Yeah.
You know, and it's not like I'm trying to cape for criminals. Some motherfuckers need to be in jail. You do some foul ass, bonehead, crash dummy ass shit.
In jail for sure.
You need to be in jail. Hey, and just like, you know, referring to the case that we were speaking about earlier, that's why I don't be big on that beef shit, on that beef culture, on that op culture. You know what I'm saying? It's like, nigga, young niggas can't get around a bunch of young niggas and not have no issues.
Right.
I'm starting to get tired of it. I'm starting to look at these niggas as weird. Like, bro, you can't ever be around some other dudes. And it's just, when you add the gun play and all that type of shit in there, these type of tragic outcomes is what are going to happen. You know what I mean? Because you can't, sometimes, man, hey, there's kids in the 80s that was running their ass off and got caught and caught a quick ass whooping. And if you ask them, hey, man, don't you wish you had a 38 special in your waistband when them niggas was chasing you? They will tell you no. Because hell no, I was scared. So I'd have pulled that shit out and killed one of them motherfuckers or something like that, and now I'd have been facing, you know what I mean? Not having a gun has saved me from doing some things, bro. Like, that's why I got rid of the one I had for a minute. Like, now that I'm older, a lot more like emotionally stable, okay, it's different. Because now if it's, you know, like we were speaking off air, it's like, bro, unfortunately, man, we have to teach the law, and we have to teach what our rights are, not just socially and not just civil rights that we have to fight for all the time. But, yo, you know, as a man, you know, if you're in an altercation and you have a legal firearm on you and you fear for your life, you have a better chance of getting off on self-defense. If that's illegal, you're participating in society with that legal firearm. If Kyle Rittenhouse had a trap gun, that AK was from the trap, from the street, serial numbers, the whole thing is criminal.
Right.
And once it comes in and it's introduced as criminal in that way, it's introduced as violent. Like, it's, you know, like the whole purpose of you having that gun was to commit violence. That's why you took the serial number off, so we could never track it. You know what I'm saying? Yeah. This was crazy about this shit, fam. And then we could wrap this shit up, bro. Why we live in a society that they're tracking down who sold Mac Miller bad dope.
Mm-hmm.
They're tracking down who sold Michael K. Williams bad dope, these celebrities. These rich kids that OD, they're tracking down who sold the dope, where it came from, all that. But you're telling me you can't stop these motherfuckers from flooding our communities with it. Like, you got to pick one. You know what I'm saying? Like, they flood our communities with these elements. And then if people that they deem unworthy of dying that way, then it becomes tragic. We have to get on our investigative shoes and figure this out, and they usually do. How come you never hear about that with guns? So-and-so pulled a gun out, shot so-and-so. The person that bought that gun originally from the manufacturer, from the store, they're responsible for it.
Right.
Unless you can show me a little bill of sale that said you legally sold this to Keem, right? Boom. Nah, I bought this 10 years ago. I met this guy Keem. He wanted to buy it. Here's my little documents right here saying that I sold it to him legally. He's now the legal purchaser and owner of that gun. You can't just sell a motherfucker a car.
No, you can't. Yeah, you gotta.
Like, think about that shit.
Sign titles over. All
Think about how much shit you can't just give to a motherfucker. But I can go to the store right now, buy a gun, nigga, and pass them shits out like candy.
Mm-hmm.
Right? But think about it. Like,
no repercussions.
It's just too easy of a loophole.
Right.
It's crazy. What do niggas do? I mean, I know niggas go grab guns, shoot right to Cali.
Yeah.
Y'all niggas out here killing, niggas dying, nigga. Y'all in a war zone. And we in Nevada. That's how guns come to Chicago. They come from Indiana. Mm-hmm. Indiana's the Nevada to Chicago. Oh man, we got gun shows every week here. All you gotta do is have an ID.
Right.
Niggas up there uploading on guns and going right back to Chicago, selling them to young black and Hispanic kids and poor white kids to kill each other, to commit genocide, to really just knock off generations. We're not gonna continuously blame the shit on black kids and black people.
Right.
You know what I'm saying? But that we're affected by it the most. But other motherfuckers are participants in it full body and have been. So it's something that we all need to just stop and think about, man. Like, when you say that a young man's brain isn't properly developed or fully formed to 25, you can go to war and fight for this country, fight for the rich at 18. You can smoke at 18. If you're a woman, you can go dance naked.
You can't smoke at 18 no more.
Well, no, not no more. You're right. If you're a woman, you can go dance naked in front of men at 18.
No, you can't.
They changed it?
21.
Okay, well, I respect that.
Can't be around alcohol no more.
I'm glad I'm grown. So, I mean, I respect that. But these are the traps, bro. These are the traps, man. I hope that young people are paying attention. You know, like my nigga Ho said, the evils. These is the evil. Then go listen to that Reasonable Doubt. Get y'all some game. The problem is a lot of these MCs ain't kicking game no more neither. They're just telling you to do drugs, fornicate, nigga, and party and kill your ops. It's literally all them niggas talk about. You know what I'm saying? So we got to do better, man, as a community. Shout out to everybody. You know, peace and love. As far as that old situation with old boy, I think that's going to have to come from the community, his family, his support system. They're going to have to write some of these politicians. They're going to have to get some people on the line. They might even have to go get Kenneth on the line and be like, bro, you need to come in and help right this wrong. You know what I'm saying? All those things. But we'll see. You know, a lot of people don't have that type of support, fam. And it's a sad story because I got a good friend right now doing life behind some bank robbery shit. This nigga's a former college football star, college graduate that was working at the bank. His homies went and robbed the bank from his neighborhood. He's driving home from his other bank, sees them a few blocks away, but before he got on the freeway, walking, and was just like, oh, bro, y'all going back to the hood? Like, I got you. Yep. Jumped in the car. By the time they get to the neighborhood, the boys draw down on them. They all screaming like, you know, let them know like, hey, yeah, bro, you know, he ain't have nothing to do with that. This is what happened, boom, boom. They like, nigga, so what? He ain't had nothing to do with it. That's what y'all say. Y'all criminals. We don't believe y'all. And he a young black man that's not rich, nigga. He don't got millions of dollars to go do whoop, whoop, whoop. He don't got no political power. So guess what?
Your ass is accomplice and going to prison.
Nigga, he a freebie. We got 2 for 1.
He a freebie. That's fucked up.
Because you got to go watch the 13th Amendment. The 13th Amendment is slavery.
Yeah, I've seen that. Yeah.
You know what I'm saying? It is slavery, and it's particularly geared for black people. Like, yeah, we ended your slavery, but if you ever break a law, we could put you back into slavery. Mm-hmm. That's why the prison systems are filled with black bodies. Not that black people just commit more crimes. They go to prison more for committing crimes. That's a fact. So we getting that on that, bro, unless you got something you want to get off. Everything else, man, I'll just wait till next week, bro. It's already about, yeah, man, we already been on here. How long?
Almost 2 hours.
Yeah, man, we could dub it.
Hold on, no. There's one thing I do want to talk about.
Get your shit off, my boy.
Oh, boy, that just... Because we'll talk about Amir next time. But that one nigga, the old flaunting ass nigga, got himself popped.
Who you talking about?
What's his name? Hush Puppy.
He got shot?
No, he got arrested. You sent me the video.
Oh, okay, yeah, no, okay. You was talking about on my docket.
Yeah.
Right, yeah, okay, yeah, no, that's what I said. You want to talk about that one?
Yeah, I do.
All right, we get that shit off.
I remember, like, he was getting busted, but I remember not hearing nothing about him, and then you brought it back, like, Jesus Christ. Like, niggas just can't be smart criminals. Niggas gotta flaunt the shit. Niggas gotta be all over Instagram with
You know
the
what
shit.
it is, bro? Niggas
like,
believe that it's real.
Right.
Cats will get money however they get it illegally. And because they can go to the Louis Gucci store or the Benz dealership, or they can go buy homes, they can go buy jewelry or any nice things, they can travel and do all this shit. See, what happens is, like, we're humans, bro, and we're tribal by nature. You start hanging around rich people that can afford the life you're scamming, you'll start believing you're one of them. And they'll accept you. They inviting you on trips. Y'all partying together.
Right.
You coming over being godparents to kids and all type of shit. They don't know that you niggas scamming, nigga, Bertie Madoff style, nigga. You know what I'm saying? But, yeah, dog, you start to believe that shit. You forget, like, nigga, I'm a scumbag. I'm out here, nigga, in the slime part of the world. Let me, a lot of them don't humble themselves. Because you make type of money Son made, there is no reason why you should still be a criminal. Fam, if you make $300, $400, $500 million illegally, how are you still a criminal? What are you still scamming? I ain't got nothing but legitimate businesses, fam, and just property and just living.
Right.
I damn sure don't have. The last thing I have is a fucking Instagram page. See, that's for celebrities, fam. Rich people, celebrities get to do that. Because guess what? If I'm Hov or something and y'all catch me on an Instagram and I got a $3.5 million watch on and the IRS come knocking, that was a loner, P. You see what I'm saying? That was a loner, man. That was just for a video shoot I was doing that. I took a couple pictures. It's different.
Right.
Ain't nobody loaning you scamming ass nigga. You a poor nigga from Nigeria and popped up in America and all around the world, nigga, scamming, nigga. You buying shit that's one of 7. You don't think they vet? Guy Ritchie just got out of prison. Dr. Guy Ritchie now. I shouted him out when he got out on the pod.
Oh, wait, Guy Ritchie, the producer?
No, the street nigga, Nicky Barnes told on because he was his lieutenant and Nicky Barnes was holding it down. They was all getting hundreds of M's, but he started messing with one of Nicky Barnes' joints that he really liked and was just like, nigga, I'm snitching on you niggas. You smashing my chick. And I told y'all niggas she was off limits. You can have any chick in the world, but you want to smash her. That's what kind of turned him, allegedly. But Guy Fisher. I said Richie, huh?
Guy Fisher.
My bad, brother. I said Guy Fisher. Guy Fisher. Out of heart. Man, Guy bought the Apollo. When the Showtime of the Apollo was still on TV and popping in the late 80s and shit, he was up so much, he bought the Apollo. And that's, again, forgetting what you're doing. You buy the Apollo, you outbid some white companies and ownership groups, and out of jealousy they get to snooping like, who the fuck is Guy Fisher? Some black guy from Harlem? How the fuck does he got the money to buy this shit and outbid us? Who is he? And then they just start looking into you. Nigga, like, out of jealousy and curiosity. Like, who the fuck is this nigga? That's exactly what happened to Hush Puppy, fam. That's exactly what happened to Hush Puppy.
It's just niggas, I don't. I don't know, bro. I mean, I can't say because if that much money, I probably.
You probably what?
I probably do the same shit. I probably be on there flossing a little bit too much.
You be stupid. Dog, if you get 100 M's
Yeah,
illegally, he had way more than 100 M's. But if you get 100 M's, no, I'm just say this. Anybody that can hear my voice, if you get 100 M's illegally, fuck it, 20 M's, 5 M's, 3 M's, but we going to go to 100 because that's what son had. He had hundreds of millions of dollars. If you get up with a quarter to half a billy
and you fucking
illegally,
shit,
no. And you have a social media page, period, you're a fucking idiot. Because, hey, guess what? It's a lot of niggas that make illegal money that go buy Bentleys, Ferraris, and all that type of shit and don't get caught because they're not showing it on Facebook afterwards. The IRS don't catch everybody that buy a Lamborghini, nigga, that didn't make the money legitimately. The IRS don't run down on everybody that buy an AP, nigga, or a Rolex with illegitimate money. They don't do all. That's not how that works. Oh, but when you doing the money phone every other episode, joint, nigga, you got this on, you switching up whips, nigga, whoop, whoop, whoop. Yeah, that's people. Yeah, okay. Hold on. What you doing? That nigga discography say he got 6 songs on the charts.
Who? Hush Puppy?
No, what? He only got 6 songs?
Oh, yeah. How the fuck this nigga got $100 million, right?
Bro, how in the fuck are you running around here, nigga, trying to battle Hove in a watch off? Nigga, you got one song, nigga, that didn't even chart barely. You got 15,000 Instagram followers.
Right.
Come on, fam.
But you over there smacking right now and all the shit.
You in McLarens and all type of shit. Nigga, you pushing packs, nigga. What is you doing? You doing something? You scamming? You doing something?
Yeah, nigga.
Because, bro, all you got to do is look at the niggas that's really up. And if you're really trying to get in and blend in with them, see, this is what the real gangsters did. They act like real rich people. Think about it. Frank Lucas was going in on his little brothers and nephews for what? Being flashy, being flamboyant. Nigga, you can have a nice car. You can have bad bitches. You can do all that.
Fucking flashy ass suits.
But nigga, why are you in Harlem tonight? Why are you doing this shit here? You rich, nigga. Won't you go to Jersey? Won't you go somewhere else? Won't you go to Atlantic City? Go to Vegas for the weekend. Why are you in where we at? Why are you sitting where we lay at?
Right.
And that's what people have to do. Even when you start talking about these cats that get themselves offed. God bless the dead. Nigga, I'm up 200-300 million and I'm in the hood that I escaped. That ain't how you show love to the hood. You show love to the hood, nigga, by redoing that basketball court that sucked, nigga, that you grew up nigga, shooting over and fixing the grass field and doing shit like that. Nigga, you know what? I'm going to go add heat to all my projects in my project building, right? I'm going to make sure everybody got good plumbing and everything straight, you know, in my neighborhood. On my block that I grew up on, nigga, them 13 houses, I'm going to make sure everybody that lived there, nigga, own it. It's a lot of shit you could do without being in the hood, nigga, showing off to the wolves, nigga, that nigga, everything I got on could change your life. From the pinky ring, the hat, nigga, to the shoes I got on, to the jacket, to the jewels, the money in my pocket, the car I'm driving. If you willing and you ready for it, everything I got on could change your life. Why would you do that? You know what I'm saying? Fam, no mob boss was running around in those Italian neighborhoods without security. You know why? Because they were extorting the Italians in the neighborhood. So I could be a mob boss and a Godfather, and out of fear, I probably can walk up and down the street without people even testing me because they know what would happen. But nigga, if I don't have security and that rep ain't out there, it's over.
Mm-hmm.
Poor people will chew me up.
Right, fast.
But shit, you ready? I'll let you get yours.
I'm doing anything. I'm going through settings and shit on my phone.
I know, that's what I'm saying. Let's go ahead and wrap this up. What you got? You ain't have nothing else? All right, bro, yeah, because those rest of the shit's weird.
Motherfucking prayers out to Tyrese, mama. She's in a coma right now.
Damn, yeah.
Is it pneumonia?
Yeah. COVID and pneumonia, man. God bless her.
Oh, the homeboy Too Much said anytime y'all want to jump in the car, drive to New York, go shoot that nigga ASAP. He said he with you. He said he
Let's
hot.
get that nigga.
He said he hot.
Hey,
He said he mad right now.
Hey, funny thing is, nigga, that nigga from Harlem anyway. Nigga,
Right.
he ain't even no Brooklyn nigga, man. Like, that nigga, man.
I've been meaning to tell you that, but every time we always be
that nigga,
rapping,
man.
we always be in some shit. But he said, nigga, anytime you ready to jump in the car, head to New York,
That's funny.
they gonna knock the nigga top off, bro.
ASAP got niggas in their feelings over Riri, bro. Like, nigga, how dare you put a baby in her? We already knew you was doing your thing. We was cool with that, all right. But she ours, nigga.
But now you done took it too far.
You see Drake unfollow both of them.
Did he?
Yeah, nigga, hold on, bro.
Drake was touched.
You don't do that to my joint, nigga. Like, that was cool. I was keeping it P, nigga. You own her. Okay, that's cool. Oh, you trying to do permanent
You
shit,
supposed
nigga.
to get her back to me later.
You doing permanent shit, nigga. I ain't say you can have it. You feel me?
You can borrow this shit for
I
a
ain't say
minute,
you can
slide
have
it
it, my
back,
nigga.
my
Like,
nigga.
you cheating. All right, my nigga, that's what we doing. All right, you cheating, nigga. You gonna go, all right, you gonna go make a lifelong nigga thing with her, nigga. Like, yeah, bro, niggas is sick.
Thingery.
Think about the billionaire that lost her. That's what I like about it.
Oh, the billionaire that lost her?
I like that a swaggy hip hop nigga pulled her. Bring her back to the culture, dog.
Right.
Bring her back to the culture. I'm glad she ain't gonna do no corny shit. You know what I'm saying?
Right. Well, that's been another episode of the
Always Talking Shit, no.
Your boy Doc on.
It's your boy King Magic.
And we out this bitch. We'll see you next week.
Peace.
You and how you feel.
New Always Talking Shit Show.
Well, fuck you.
tell you about a young nigga, he was only 14. Don't fuck with niggas, he stay social distance like he quarantined. Went from NBA to torn dreams, and a street legend in between. Desperate prayers made him hit his knees. He was born Cabrini Elwood back in 99 on Chicago North Side, where the news report. Yeah.